range, say, animals of digital constitutionalism, understanding what is its and the title. I mean, it's quite self-explanatory, saying is old wine in new bottles, or it's something really new, execution of constitutional law. Now, I changed a little bit the style of my presentation because thanks to the sparring colleagues that talked before, I understood that maybe it's more useful for you to know a little bit more about how I got to this topic, how I got to this field, which are, let's say, my roots, and then clearly in the second part of the presentation presenting more in a more technical, let's say, deep way, which are the main research questions, and then the third part will be devoted to criticism, I hope, and questions. So the first part is related to one of the first conference about cyber law, Chicago, by the way, 1997. It was Easterbrook that was a judge of this district court. I'm sure Louis and you also know very well. I think it's still alive, I hope.
Yes.
Yes, it's good. Yes, and what he wrote, it was a very provocative paper. Law of the animal or law of the horse. Cyberspace. The title was Cyberspace and the Law of the Horse. And basically, the idea was, I'm dealing with intellectual property law as a judge since the last 30 years. Now I have the first cases related to a new technological dimension. This internet is not anymore the words of atoms, but it's the words of bits. Should I change everything that I did until now? Should I find new rules for the new? Should I find new rules for the new technological dimension, the law of the horse, or should I just apply clearly with a reasonable sense, with evolutive approach, the old classic traditional principle of intellectual property law? And this would be the law of the animal. So a Unitarian approach or new rules for new technology. Please keep in mind this because it will be clearly one of the most important questions of my second part. But I would like now to speak about my law of the animal, which is which are basically my roots and my, let's say, more general categories that brought me here today to speak about digital prostitution. I don't believe in the law of the horse, just to be clear. My background forced me to believe in the law of the animals, in a Unitarian approach. Why? Because I'm not a technological lawyer or scholar. Not at all. I can tell you more. I don't understand so much about technology. In terms of scientific approach, I'm trying clearly to improve this because if you don't have this technological approach, it's quite difficult then to be convincing. But I was not born as a technician, but my first love was European Union law. And I fell in love with European Union law at the College of Europe in Bruges. After 3 attempts, I was finally accepted. I was basically after my graduation in Messina, in Sicily, very, let's say, exotic island, and very exotic law school. I wanted just to escape from my university and from my town, frankly speaking. And I want to try something new. And I had this College of Europe as obsession, because I didn't do maybe this is just personal, maybe you're not interested, but I think it's important for me to share you in order to understand why then I apply a certain methodology and not another one. Basically, what I did was to try to apply 3 times for the College of Europe, and in the meantime doing a master in Bologna about European law. I did this European law master. I was very disappointed. I didn't like it all. And in the meantime, I got refusal the second time from Bruges. It's time to go back home in Messina. It's not for me the European law dimension. It's not for me even the scholar dimension. I started to practice law in a law firm in Messina. Then I tried for the third time, and finally I was admitted in Bruges. And then my life changed, and also my research approach changed. Started and changed because I understood that for me it was very important, very interesting. I would say the law-making activity of European countries. This was my first love. Again, speaking about, if you can speak about love, about law, clearly, not with all due respect. But let's call love. Basically, I was totally fascinated by the way in which European Court of Justice, we were speaking in the bus before, how the Court of Justice basically was able to rewrite the treaty, the European treaties, the Treaty of Rome, in an astonishing way by injecting a principle, it's the primacy. We spoke yesterday about the comparison between the San Jose Court and the Strasbourg Court. The primacy principle that was not in the treaty, and was not at all the will of the states to have primacy. And I was totally fascinated by Eric Stein, for example, no? Speaking about the Court of Luxembourg hidden in the fairy tale Luxembourg state, was able to create a constitutional doctrine by a common law methodology in a civil country frame. Quite paradoxical, but this was what happened. And so basically, I came back from Bruges with this great enthusiasm for the judicial activism, which are the boundaries of judicial activism, because clearly there is also the issue of separation of powers here. No? But then I started my PhD not in European law, but in constitutional law in Milan. And in a way, I was forced to find a kind of, let's say, connection between constitutional law and European law. As you see, until now, digital is a ghost. Mm-hmm. I think it makes sense because it's a law of the animals. It's not a law of the horses. The connection was the interaction between legal orders. Interaction between European legal orders and national legal orders. Interaction between the European Court of Strasbourg, the European Court of Justice on the one side, and the constitutional courts of member states on the other side. And I sent you the first book that is exactly about this. It's interaction between the European legal order that you can find in your mailbox. You will find soon, if you don't find now. This was, in a way, my first attempt to build a kind of theory of judicial dialogue. Sometimes it's judicial monologue, sometimes it's the constitutional courts raise voices, like Cashew and Rome, no? But for good reasons, like sometimes the Colombian Constitutional Court. And this was basically the first theoretical frame of my research, that it was related to interaction between legal orders and interaction between courts. Now, there is the second step, the second season. After we published a lot on this, I was interested in clearly expanding the scope, always in the world of atoms, so we're not speaking again still about digital, to the other side of the Atlantic, especially the United States. And clearly, the first judgment that you read in general as a beginner are the judgment about First Amendment. And in particular, in that period, there was a very important judgment, one of the first, but here we have prominent United States scholars, so I don't want to sound sure, but one of the first about internet law, it's a Reno judgment, 96, in which the Supreme Court says something very important. It was there that I started to be very interested in the digital dimension, in the internet dimension. The Supreme Court is saying internet is the new free marketplace of ideas, using a legendary metaphor, no, of the. This I'm quite sure about this, about the dissenting opinions of Holmes in Abrams many years before, and using these metaphors, that is one of the most important metaphors in comparative constitutional law, for internet as the new free marketplace of ideas. And then as it comes to my mind, a new research question. How is possible to assess the standard, the degree of protection of fundamental rights when there is a shift in the technology, when there is a shift from the world of atoms to the world of bit? So basically, the standards of protection of fundamental rights are in a way impacted by the change of technology. According to the Supreme Court, there was an enhancing, I would say, enhancing injection for the First Amendment, even more freedom. It's already, let's say, holy, I would call it, in the world of atoms. It's even more, let's say, great, the protection in the world of bit for the Supreme Court of the United States. So basically, you can call it digital trust. The Supreme Court is believing that, and then you will see in the second part of my presentation that this is confirmed by a recent judgment. The Supreme Court is believing that the internet is a technology that's enhancing freedom, at least freedom of expression. And then comes the third season that is related to my interest in policy making and in trying to support the European Commission. Now speaking again, we came back in Brussels, to try to fix and to, let's say, establish a strategy for fighting against disinformation. It's 2018. It's the first strategy of the European Union to fight against a new phenomenon. It was not new at all, again. It's a law of the animal. It's a fake news that existed since centuries. It's obvious that in internet there is an amplification of the problem, but it's not a new problem. Like it's not a new problem right to be forgotten. I mean, again, law of the animals rules. But what was important for me, it was that metaphors when I was in Brussels in 2018, because we needed to discuss which should be the right policy-making option for European Union in order to fight against discrimination. And many scholars coming from the United States, but also from Europe, believe that the receipt was free marketplace of ideas. Meaning, in terms of policy making option, self-regulation. Meaning, basically, step back from public powers in order to enable the free market to find its path, to find its route. That believing in self-healing ability of the market to heal itself. I think this was a mistake, and I said it was a mistake for the simple reason that already in the United States, as our prominent colleagues can tell much better, the free market of ideas is a theory that, I mean, has some, let's say, controversial, let's say, paths. It's not at least unanimous considered as the theory as it was some years ago. But beside this, I want to focus about European direction. And my statement there was, be careful, because migration of constitutional ideas are dangerous. Metaphors are dangerous. I think that it's very important then what I studied before about metaphors. Trying to let's say, be inspired by cognitivist scholars like George Lakoff. No? Metaphors we live by, 1980. Metaphors are a way, a language tools to make more familiar a prototype that is not familiar. And you do this by metaphering in Greece, means to shift a concept from a familiar domain to a not familiar domain, okay? So, but it's a very dangerous operation. Why? Because if you don't do properly, then there is the risk to have a reject of the constitutional ideas, a reject of basically of the metaphors. And this was exactly what also Milan Kundera is saying in the unbearable lightness of being. No? I'm sure you read. And I was, for the first time, interested in methods, reading that book, reading what Thomas, the protagonist, said, or at least what Mila Kundera is putting in the work of Thomas. I didn't understand that the metaphors are dangerous. You should not joke with metaphors. And in that case was exactly the point, if you think about it, because the idea to import from a totally, not different, because we speak about the constitutional democracy, but from a slightly different constitutional culture that believes more in freedom and liberty, whereas in Europe the key word is dignity. I don't want to sound now, let's say, rhetoric using the famous dilemma dignities versus liberty because it's too simplistic. But it's true that in Europe we have other values that goes hand in hand with freedom. And that dignity, no discrimination, and basically to try to import that metaphors was very dangerous. Why? Because in a way it was a little bit of betray, if I can say like this, about the European constitutional values. That in a way implies, from a policy-making point of view, the needs of an action of public power. What does it mean? It means if the self-regulation is not the receipt in Europe. By the way, as a footnote, I think the self-regulation is not the receipt in digital law at all. Because in general, self-regulation means that the private platforms that are basically the targets of the regulation should be the one to write the regulation. And as you can imagine, they will never write something that goes against their business model. There will never be an incentive to increase the efforts to protect the rights. But this is obvious, because markets rules. So basically, this is the third step. The third step was related to, if you want, I can do it out. I think that they can hear me. Yeah, I'm sure you can hear me. And then there is, so basically, in order to just wrap up, the first idea was related to constitutional laws.
The microphone is for the translation.
No. I think it's compulsory. Yes, for the translation.
Yes.
I thought it there was a lost in translation. Yes, thank you. Because I was. Now can you hear me? Yes. So just to recap, the first part was, let's say, interaction between legal orders. The second part was related to how this frame that I tried to build from the work of others, in particular judicial dialogue, relationship between courts, how does it work in the work of it? A third, I tried to study, and I was in a way involved in the work of the European Commission, trying to adopt a new code against disinformation. In 2018, and even last year, we delivered finally this code to the Vice President of the European Commission. And as you can imagine, this experience, this practical experience, in a way inspired me in order to try to find which is the best policy-making options in order to deal with this new challenge. So basically, trying to take inspiration from all these, let's say, roots, this kind, my personal law of the animals, I started to think about powers, very simply, about how the geometry of powers is changing in digital context. And in particular, I'm saying something obvious, the geometry of powers changed from at least a vertical dimension to a also horizontal one, no? Because we are absolutely, let's say, accustomed, and we are, let's say, very, we know that in general the geometry of powers is vertical, no? Public power versus individual, no? What is called frame of state, no? In constitutional law category. But it's obvious that powers can change geometry. And if before this slide, I would like to start to continue with this one because I would like just to focus on something more. When powers change geometry, from the vertical dimension, there is also the horizontal dimension, meaning that we're speaking about private powers. There is, first of all, a need to not betray the DNA of constitutionalism. That is, to limit power, independent from where this power is coming. It's coming from the public authority, it's coming from a private operator that has the strength and the money and the ability to influence the debate as a public power. Doesn't matter. In any case, constitutionally, it's about limiting power. No? So this was the first assumption. The second was, which are the characteristics of these new powers, I would call the digital powers, that are differentiating such powers from the previous private powers? Because it's not the first time that the constitutional law has to do with private powers. Thanks to the sporting federation. They have an impact on a certain market that could be considerable, comparable to a public dimension, but which is the added value that explains why we can speak about digital constitution as something not totally meaningless. This new private power has a business model, the aim to influence, voluntary or involuntary, the communities of ideas, what is called free marketplace of ideas. Basically, what they do or what they do not do, then it's going directly or indirectly to influence how we get information, how we share information, how we are informed, and how basically is shaped what is called public forum. So basically, this is something that it never happened in the past, no? In terms of focusing on this added value of the new private powers. And this is the reason why I started to ask to myself a few research questions that you can find here, and I will not speak in depth about it, but you will find in the book that I shared with you, the last book about digital constitutionalism. And this is exactly the question of Easterbrook, no? Many years ago. Does a change in the relevant technological environment lead to a significant impact on judicial protection for fundamental rights? So basically, the degree of protection of fundamental rights is changing according to the technology, and if the answer is positive, which is the degree of protection? There is an increase or decrease of the degree of protection. Second, what is the impact of digital technologies on the relationship between judicial power and political power? This is something very important, because since I was very interested in judicial activism, you remember my first season, it came in a way spontaneously to think, but which is the role of courts in the digital context? Are they empowered? Are they in a way getting even more powers in the era of global judicial globalization in slaughter terms? A digital judicial globalization, even an amplification of such powers? In case of positive answer, which is the reasons why they are getting more power? And the answer is quite simple. One is obvious. The legislator is sometimes impossible, sometimes unable, sometimes simply doesn't want to adopt new legislation that are technologically fitted, and then clearly courts need to have this kind of replacing role, no? That you know very well. if the legislator is passive, in general, courts are active, and vice versa, like Federico Mancini was saying for the European Court of Justice. But there is also another reason, and this is in a way interesting because it's the American courts, strangely enough, that started this exercise. You know that one of the first assumptions about the Internet law was that Internet is an anarchic space, meaning it's a space in which public powers should be very far and should not be basically related to these new communities that is totally, in a way, disconnected by the real world. What happened was that the courts in the 90s in the United States, in order to eradicate their jurisdiction in certain cases, show to this kind of anarchic school that it's not true at all that there is no possibility to have for public powers, in this case for judges, a role. Because by eradicating the jurisdiction, by adjudicating the case, they were showing that it was possible to regulate, at least, a kind of judicial regulation of the case. So there was a further amplification of the judicial power. I don't know if it's clear. And clearly this has an impact in relation to the limits of judicial power in relation to the legislative power, because at the end of the day, and the European scenario in digital law is very emblematic on this. If you delegate courts to basically adopt rules that should be adopted by legislative power, there happen two things. First of all, the question of legitimacy for courts. Secondly, fragmentation, jeopardization, harm of legal certainty, especially in a market like digital market that needs certainty. So basically this was the second problem. Then there was the third question, which are the new challenge for constitutional law. In other words, and I'm trying now to go quite a little bit more quickly because I would like, first of all, not to bore you, secondly, to leave time for questions, etc. I know that there is a visit to the campus, which is much more interesting. Digital constitutionalism, it's something that it's just a new way to have fashion titles in fashion or not fashion titles in journals, or there is a normative value. And if there is, which should be the normative value? Because this is one of the most important points today in the digital constitutionalist debate. No, I was speaking about just the informative, descriptive dimension, or we're speaking about something new. So first of all, there is nothing very ambitious in digital constitutionalism. It's not a reformation, but it's an expansion of constitution in digital age. So basically, it's trying to understand which are the new challenge that constitutional law should have in order to keep its DNA, limiting powers, even if those powers are horizontal and not vertical. I'm simplifying now. So you know very well that the geometry is, let's say, a field that is very a la mode in constitutional law. For example, you know that Jake Balkin tried to shape the new ideas that I'm trying to share with you in a triangle, no? Which you have governments, individuals, and then you have a third new protagonist, the intermediaries, that you can call platform, you can call the internet service provider, you can call it such many ways, because unfortunately the European legislation is calling in many different ways depending on legislation. So, you know, changing names doesn't help legal certainty, by the way. But let's call intermediaries, let's call private powers, okay? So I think it was quite successful, this idea of Jake, and I don't want to clearly go. I have not the ambition to try to have a new geometry, but I just want to reflect with you which could be a new triangle that it's basically related to a kind of shape of digital power. In the article that you found in your mail, by the way, as a footnote, you will see that the article that is going to be published in European Law Journal has a lot of comments by the editors and by the referees. It's not a mistake. I wanted to show you how also in the final stage of application process there are so many comments to respond and so many things that you should work in order to be published. So it's in a way work in progress, and I show you that the pseudo final version had already so many things that I should work. And you will see, unfortunately for me, every single comment that I had to answer and every single request for modification, for change. Now, I will be very brief. What does it mean, a triangle or a quadrangular shape? Because in the article I add another element I called a quadrangular shape. That here I don't put the fourth element. The fourth element is the reaction by constitutional orders to this kind of threat. Very briefly, you know very well about the values. The values are in the umbrella of liberal democracy, but honestly are a little bit different, because you know very well the holy value of First Amendment. If you don't know, don't ask me, because you have at least two persons here that know much better than me the case, so I will not say anything. And you know very well who is this guy. It's Holmes, and when in Adams in 1919, basically he shaped this legendary metaphor. That he didn't speak about free marketplace of ideas in the literal terms. Now then it was reframed, as you can see. But this is the idea: the competition of ideas and the belief in the self-healing ability of the market of ideas. What does it mean, this, from my point of view? And this was the discussion in the European Commission. Shall we believe that the false news have the same, let's say, legitimacy to be in the free marketplace of ideas as the real news? False opinion are really in a way enabling to find the real truth, or today, when the market is much less free than when Holmes, by the way, drafted the opinion. It was a laissez-faire period, not at the state, but in general, we cannot say the same thing now in relation to the internet market of ideas. You know, you remember when we said about metaphors? There is a domain names from which the metaphor is taken, and the target domain where the metaphor is landing. We should be very careful in trying to see if those two domains are the same. Because if one of these two domains is changing, then the metaphor will be rejected. This was my point to the European Commission. We cannot apply these metaphors today, it was 2018, when we have so many oligopoles and so many, let's say, problems, not only of competition law, but also of constitutional law, because Her Majesty competition law is not anymore the only one that is useful for this frame today. Constitutional law needs to be hand in hand with competition law, because it's not anymore an economic power, it's a political power. It's true that Sherman Act had this kind of, let's say, approach, but the European competition law don't have this approach, as you know very well, because the political power was delegated to the state. Otherwise, they would never accepted the deal in 1956. Now, the values are different, because as you can see, there is something about freedom of expression, but also other rights, that is simply not receivable by United States constitutionalism. Limitation, codification of limits for freedom of speech. Codification of limits. There is the rights, but there are also limits that are codified. Now it's obvious the Supreme Court provided some limits. Otherwise, that First Amendment should have read in a way that was basically unlimited. There are limits, but they are not codified. It makes all the difference in the world, the codification of limits. This is the difference in relation to values. Let me say just another thing about values. There is something that, I don't know, then I will ask Carlos if there is also in the American Convention. There is a concept that is, I think, European, that is not known by United States constitutional law, that is the abuse of rights. What does it mean, abuse of rights? The codification of the clause of abuse of rights. The rights to be exercised, but to be also abused is for Article 54 of Charter of Fundamental Rights of the European Union and Article 17 of European Convention of Human Rights. This is very important because we can speak about disinformation and fight against disinformation only if we have a theoretical humus, the idea of abuse of the rights. Otherwise, we will receive the answer that the Supreme Court gave. There is not fake news under the First Amendment. At least this was one of the statements. Now I know that in the United States they are starting to change, not to change, but to ask if this kind of approach can be still convincing in this totally different time. But it's obvious that if you speak about abuse of rights, abuse of freedom of the exercise of freedom of expression, then it's there that there is the theoretical legal basis to fight disinformation. I hope it's clear. In any case, you will get the slides. So, very briefly, which is then the reaction when there is a shift from the world of atoms to the world of bits? Which is the reaction of European courts on one side and American courts on the other side when there is the shift from the world of atoms to the world of bits? Reno, 1997, we already said this, no? There is an amplification of the existing freedom. I would call digital trust. The American courts are basically, and I'm simplifying, seeing the new digital technology as a means, as a tool to enhance the already existing freedom. And this is also very true in Buckingham case, that it was a little bit more recent by Supreme Court in 2017. Cyberspace is the vast democratic forum of the internet. This implies a footnote that I have not the time here to deal with. What does it mean, public forum, in this case? They are using the public forum doctrine in a descriptive or in a normative way. It's not my question, it's the question Alito Reus to Kennedy, they wrote the majority opinion in this case. Because he said, if you are using the public forum doctrine in a normative case, then you are basically challenging the state action doctrine. Now, I don't want to go in detail in this, but basically there is a huge difference between the United States and European Constitution in terms of horizontal application of fundamental rights. And this is very important for the internet. Why? Because these private powers sometimes need the horizontal enforcement of fundamental rights in the Constitution. But freedom of expression, and this in Gonzalez case, the court said very clearly, no, about the SU30 section, that we can speak about this kind of immunities, according to some of the 27 words that created the internet, but also created an immunity for such private powers. According to the Supreme Court, basically, it's impossible to apply horizontally First Amendment. What does it mean? It means simply that there is not a weapon that the European Court of Justice has, starting from the experience of the Kashrue German Constitutional Court in the 50s, no? The horizontal application of fundamental rights. What does it mean? That, for example, Article 7 and Article 8 of the Charter of Fundamental Rights of the European Union is the Bill of Rights of the European Union. Data protection can be enforced horizontally against Google. Google Spain 2014. And this is a weapon, maybe a nuclear weapon, but that the European Constitution has it. And the United States, I think, has not. So, now, in order to be quite short. You have here a kind of synthetic slide. Doing a comparison between the judicial approach in the coming from European courts and American courts, you see that American courts, in my view, as a kind of, I would call digital trust, call as you want, but for sure as the attitude to see more the opportunities of enhancing the freedom than the risk connected to internet. If you look at the case law of the European Court of Human Rights, for example, you see something totally different. You see that the European courts is more focused on the risk that internet can raise for other rights, like privacy, like protection of minors, like reputation. You can call digital trust, but for sure there is a different judicial frame, no? Taking the idea of frame by Lakoff, you remember I spoke about Lakoff, about the cognitive studies about how to build a frame, and then applying to judicial interpretation. Now, this guy, maybe you are curious to know who he is. This guy died recently. He was one of the pioneers of internet that in 1997 in the Davos Forum, World Economic Forum, stated the Declaration of Independence of Internet, saying, dear governors of public of states, keep your hands far from this new brave world, the anarchic approach. Why is important this? Because it's bringing me to speak about the second element, the space. No? Until now we spoke about values as the first element of the triangle, now it's the space. Why it's important this? Because the idea is that the internet space is far from being anarchic, but sometimes it's over-regulated by states. Thanks to the dictatorial states, thanks to what, for example, states are doing in order to try to have a kind of digital censorship. There is a very interesting book by Tim Wu that the title is Who Controls Internet? It's interesting because I think it's 2001, no? Maybe later, a little bit later. By the way, I don't remember the co-author. In any case, it's for sure Tim Wu that he wrote this book. It's interesting because it's exactly going against this assumption that the space in internet is anarchic, and showing that states can regulate, over-regulate internet. Then you have the third element that are the actors, the new actors of this new frame. Now look at this, and look how these actors have been unregulated for a long period. I call this digital liberalism. You can call it as you wish, but the idea is clear, no? The idea is, for a long period, starting with the Section 230 of the Communication Decency Act in the United States, and then borrowed by the e-commerce directive of 2000 in the European Union, there was a kind of delegation to such powers to basically do whatever they wanted. Let me say like this. Why? Because the idea was to promote internet as a new business model. In order to promote e-commerce, the idea was to avoid any kind of responsibility for such new actors. Otherwise, the risk would be what is called collateral censorship. Those actors, in order to avoid to be convicted, they would basically remove every single content. And they should not have been anymore the gatekeepers, the amplification of the information, but the self-censors. Now, this idea worked until a certain period. When there was a big transformation, in my view, a transfiguration of these actors. From economic actors, this means exercising freedoms to conduct business, to be real private powers competing with public powers. When did it happen? More or less in the second decade of 2000. And why it happens? Lessig already, in a way, predicted this, no? With the book, The Code, already in 1999. But the idea was that there was a shift from the human dimension to the automation. It's called the algorithmic society. When there was the race and the explosion of algorithms, then there was this transfiguration from economic power to private power. Why? Because there was a kind of injection of strength, first of all, an injection of lack of transparency. The second point. Because algorithms, as you know, is not exactly transparent and entails a great power. This is the reason why finally there was a reaction from the constitutional legal orders. A reaction that in a way entails to try to find the remedies for this kind of transfiguration. And which was this reaction? This reaction is clearly related to we started 1 hour ago. Okay, so I will stop very soon. The reaction is clearly related to the weapons, no? That a single legal order has. Now, I want to focus on this transatlantic bridge, even though it's obvious that it would be interesting to see also others legal orders, no? Others areas. Okay. Now, as I said, the first season is the digital liberalism, no? And antitrust was Her Majesty, simply because there was the idea that everything should be delegated to these such not yet private powers, but simply economic powers, no? Very passive, very neutral, not so sophisticated, not so powerful in terms of control over the contents, no? Then, as I said, there was a metamorphosis related to the algorithmic season. In a way, Lessig reloaded, I mean that he, in a way, predicted this in a different way. So he said that there was a shift from the political powers to the informatics. And then the further shift is from human and in the center to automation. But what is for sure that antitrust, if it's not a sunset, for sure, as a kind of crisis, no? Because it's not anymore by itself able to face this issue. Now, which was the reaction in the United States, in my view? But again, I'm not the right person to focus on this, so I will very shortly shift to the European one. There is still, in my view, the untouchable, the problem, and it's obvious, it's not a problem, it's a doctrine that has also cultural reasons. Don't Constitution, the state action doctrine will not be touched. What does it mean, state action doctrine? Shall I repeat it for you? The state action doctrine means that at least the Federal Bill of Rights cannot be enforced against private actors. Okay? And this is clearly due to a kind of step back of the states when there is a private relationship. No? It's part of the United States constitutionalism. If this is not possible, which could be an alternative? In Buckingham, you remember that there was this discussion between Alito and Kennedy, no? How to interpret the public forum metaphors. the digital agora metaphors in a normative or in a descriptive way. What does it mean? You are just describing something, or you want to claim a normative point of this. It is changed a lot, because if the metaphor that just describes, no problem at all. But since public forum doctrine is a very important doctrine that entails that only public state actors have the obligation to not discriminate in relation to the content discrimination, if you use these metaphors in a normative way, it means, according to Alito, that he was totally against this clearly. Also Kennedy was against, but it was not clear in the metaphor, the majority opinion. You mean that you are shifting this obligation also to such new private power. And this we do not want. It's true, dear Kennedy, yes, it's true, because then the Supreme Court confirmed that it was only a descriptive way. So, which is the risk of, there is a clear risk of confusion in this, which is then the possible weapon for the, I then am not calling it more constitutionalism, but I would call from, let's say, policy making options, even from the private sectors. One example is the Facebook Oversight Board. What do you know? Have you heard about this Facebook Oversight Board? It's called, let me just tell you a few words in order to be on the same page. It's called the Supreme Court of Facebook in a not technical way. It's basically a board in which, by the way, there are few colleagues, for example, Andras Shire, that he was vice president of the European Court of Human Rights, a very prominent comparative constitutional lawyer, that in a way is, they are appointed by the platform. There is a claim of independence that is clearly not immediately easy to demonstrate. And what is interesting is the standards of review. For example, in the case that related to the platforming of Trump, you remember very well what happened at Capitol Hill. You know very well that after what happened, Trump was basically banned from Twitter, from Facebook, and clearly this decision of Facebook then went in front of this Supreme Court. What is interesting, now I'm not speaking about the merits, I speak about the standard, the criteria of review. They are using the principle of proportionality, that is a European principle that is used in a decision of private body that is supposed to apply, at least in theory, the American law. So it's kind of interesting hybridization that I think at least is an interesting laboratory. I see that there are problems with legitimacy, because you cannot claim that a body is legitimate. This is self-legitimation. In general, legitimation should be given by another body. It should not be claimed by the same body. No? Otherwise, there is a little problem. No, this I already said, and we don't know what to see anymore. Reaction and remedies in the European dimension. As I said, at a certain moment there was clearly the need to do something different from digital liberalism. You remember the first period of digital liberalism. But then there was this transformation, and which was the reaction of the European legislator? First of all, there was, as I said, the horizontal claim, basically applying horizontally against these new private powers the Bill of Rights of European Union, especially data protection and privacy. This is controversial. Huh? It's not something that you can do. The European Court of Justice is not very clear on which are the provision of the charters that have the possibility to be applied horizontally and which are not, you know? Depends if they are enough precise. So it's a little bit, you know, a last resort weapon. Then there was another reaction, the reaction related to what I call fragmentation. And we have two kinds of fragmentation, the judicial fragmentation and the legislative fragmentation. First of all, the judicial one. Why? Because as you know very well, the first bodies in a state that has the possibility to identify constitutional collision and try to find remedies are the courts, no? Because a case in front of the courts is clearly give to the court the possibility to find a solution. It will be a specific solution, but will be much quicker than the legislative power. This is the reason why there was a period in which courts had a total, I would say, monopoly of interpretation and manipulation of the European legislation in order to try to find remedies against these new powers. For example, by inventing the role of active provider. What does it mean, active provider? It's a provider that is very dynamic, but is not so dynamic to be an editor, so should not apply the editorial responsibility, but is not so passive to enjoy the immunity. You know what I mean? So but it was just a judgment. And then there was another judgment related to, for example, the sophisticated internet service provider. But you know that all those cases, also by European Court of Justice, have the merit to try to fill a gap. But as every case law is creating fragmentation, there is not a legal certainty. So then there was the second season of fragmentation, that was the legislative fragmentation, because as happens also in the history of the European integration process after Maastricht, member states decide to take back the role of legislators and to finally adopt legislation that should, in a way, be a kind of reaction to the rise of these new powers. But this legislation was very vertical. What do I mean? It was legislation for copyright, a legislation for audiovisual media service, a legislation for prevention of terrorism. All those legislation had a different kind of definition about internet service provider. And basically they created what I call legislative fragmentation, because there was not a fil rouge. So it was very difficult to find the kind of harmonic interpretation of such legislation. And then there is the third and this existing season, that is what I call procedural digital constitutionalism. What does it mean? It means that the new season of this reaction is not anymore based only on substantive values, like dignity, no discrimination, protection of minors, and so on. But is related to what I call the procedural obligation, meaning the Digital Service Act. If you're interested, we can speak in another moment about this. The Digital Service Act will enter into force in February next year. It doesn't provide, it doesn't, let's say, it doesn't touch the substantive frame, no? It doesn't deal with constitutional European values, because the risk is then to create a European fortress with these strong values, very strong inside, but without interconnecting bridge with the rest of the world. It's a shame if you speak about a transnational technology like the internet. So the idea was, let's focus on obligation for this new private power, the obligation to have a hearing with the users, the obligation to give a response to the user, the obligation to explain the process, the explanation to translate the process, not right explicability. All those rights you can put, and this is a simplification, under a due data processing, due data process that in a way it's very interesting because, in my view, it's a language that can be understood much easier, much better from the United States counterpart, at least in terms of due process. Clearly there are differences, but at least the obligational procedural side, I think being more neutral in terms of value is more understandable. I mean, I know that you could have some objection on this, but at least there is a possibility to maintain or to build this digital transatlantic bridge, not only counting on substantive values. Because if we focus on substantive values, will happen what it happens already 2 times, and then with this I will end. It will happen the third time, probably in relation to the saga of shares. Have you heard about it? I'm sure you don't, because it's not so famous. But let me just tell you what it is. There is a problem in Europe. The problem is how we can transfer the data of European citizens to third countries. Because in Europe there is a very high protection of privacy, but the problem is what happens when those data goes to China is a great problem, but let's say to the United States. I think it's not such a big problem, but there is for the Court of Justice a problem, which is a problem. The problem is that according to the Court of Justice should be an essential equivalent protection that reminds, again, the great, let's say, the glorious spirit of the European Court of Justice, Solange, in relation to the protection of fundamental rights. So I think that there are some comparison in this. So this helps the law of the animals. Unfortunately, the law of the horse is difficult that you can find this connection, and then this connection simply falls. But what I want to say is that according to European Court of Justice should be an essential equivalence of the degree of protection between European legal order, United States legal order about privacy. Now this is, I think it's impossible for many reasons, starting with Fourth Amendment, starting with the great efforts of interpretation that the Supreme Court did, but it's obvious that we are not speaking about a fundamental right that was born as a fundamental right as in Europe. Now, there is a fight between the European Court of Justice and the European Commission. The European Commission said, look, we should not speak about essential equivalence. We should speak about adequacy. That is a different concept, because adequacy means it doesn't imply a comparison, the concept of adequacy. It implies that within a certain legal order should be a certain degree of protection that is sufficient. But it doesn't imply the comparison. Because the comparison will bring to what happened already 2 times, that is the annulment, striking down of the agreement between the European Commission and the Department of Commerce, United States, in relation to transfer of personal data. And we should admit, not for sure in the Trump era, but before in Obama and then in Biden, that there has been quite significant increase in the protection of privacy in the United States, in my view. They are doing some efforts, but it's obvious that if you require the equivalence, no ways. So, basically, what I think is very important in terms of separation of powers is that the last word now, maybe not the last word, but the next word should be for the political powers. Then clearly the European Court of Justice will have again the possibility to review. But this ping pong, you know what I mean? Luxembourg, Brussels, Washington, it's not helping. It's not helping legal certainty. It's not encouraging, especially the startup, to invest in the European digital market. Because I don't think the problem is for those giants. Unfortunately, there is the obsession for these giants that makes sense, because all this presentation is about giants that become private powers. But the truth is that beside this, there is a market that is done by a plurality of companies that needs legal certainty. So this is basically what a synthesis of what I tried to say until now, and I will not continue also because I think that it was enough. And thank you very much. And now I really like to, I think it was half an hour less. It would be interesting to know if you have doubts or questions or let's say curiosity about this, because it's a work in progress. I'm trying. I don't have clear ideas. It just sometimes a statement that needs to be verified, no? Otherwise they look apodictic. So I really like to know what you think in order to continue this work in progress. Thank you. Please.
Gracias. Pues una disculpa porque yo no sé hablar inglés como para
No, no,
formular una pregunta. Pero entiendo que la era digital, su exposición, la era digital cómo influye en el poder político y en el poder judicial. Pero yo voy a esto, ¿cómo influye el poder, la era digital en el derecho, por ejemplo, constitucionalmente tenemos derecho a la información, ¿sí? Pero también tenemos derecho a la privacidad. Son dos derechos muy importantes. Son dos derechos muy importantes. Entonces en México sucede esto, y especialmente en la ciudad donde yo vivo, hay una modificación en la página del registro público de la propiedad, y espero que los señores notarios que nos acompañan me puedan apoyar. Entonces en esa información uno entra a la página web y puede preguntar qué propiedades tiene determinada persona. Y pienso que eso es muy peligroso para la seguridad jurídica, para la seguridad personal de la gente. Porque, por ejemplo, los millonarios que forman parte de los consorcios están protegidos porque no aparecen sus nombres. Pero si yo quiero saber cuántos bienes tiene determinada persona, solo le pregunto en la página web y ahí me dice cuántas propiedades tiene. Y creo que esto es peligroso desde el aspecto de la delincuencia organizada. No sé si me expliqué.
No, explique. Can I answer or?
Creo que se violan derechos fundamentales.
Es que es público el registro.
Exactamente, el registro público es su función la difusión. Pero, por ejemplo, si yo voy a pedir pero es el instrumento público, ¿verdad? Si voy a pedir un testamento, tengo que ser heredera para que me den copia del testamento. Es un trámite. Pero si yo quiero saber cuántos bienes tiene una persona, solo le pregunto a la página web y me lo va a decir.
Pero cuando no había, tiene que ver con el
No.
tiene que ver con los viejos vinos con nuevas botellas. Cuando no había internet, cuando no existía el internet, uno iba personalmente y conseguía lo mismo.
Sí.
Porque la naturaleza del registro precisamente da publicidad. Entonces, sí, el riesgo ha existido siempre. Ahora es más fácil hacerlo por internet, pero
Exactamente. Entonces, mi pregunta es cómo la era digital podría proteger ese aspecto, si es que sería posible. Porque para mí es un derecho fundamental la privacidad, en ese sentido.
This is a very important question, but if you don't mind, Diego, you are the good in this, so I will give you the floor for the first answer.
Bueno, lo que pasa es que estamos aquí ante un problema de libertad digital, y desgraciadamente la libertad digital tiene sus consecuencias, y una de las consecuencias que hemos vivido todos es precisamente la difusión de la información, incluso de la información personal, que muchísima gente sube voluntariamente y andan presumiendo toda su vida. Entonces, bienvenida al siglo XXI y a la nueva realidad. Sí, ocasiona problemas, pero estas hay que, como decía Oreste, pues es una realidad que estamos enfrentando, y desde el punto de vista constitucional, por un lado se pretende regular y por el otro lado no se puede regular porque es horizontal. Sí.
Please, there was a Mary and then Bruce, please.
Thank you very much. This was fascinating. I really enjoyed it. One sort of comment I have, and I just wonder if you've explored it or how you think about, in the comparative analysis, the role of the United States as a federal system. So certainly one of the spaces where we have horizontal application of rights is through the common law, and the role of tort law and efforts by the states to take action in that space. The Supreme Court has limited that as well through the principle of the First Amendment. But comparatively, it's interesting to see how the UK has used its common law to be more rigorous and engaged in privacy. So I wonder if there's a common law, civil law divide, or now that the UK is no longer part of the EU, if there might be another stepping point in the transatlantic perspective, so that it's not just the U.S. and Europe, but maybe the U.S., the UK, and Europe, or the U.S. and certain states within the U.S. and the UK. If that then is too complicated, or if it enriches the analysis.
I think that this would reach a lot of analysis, to be frank. And this is a starting point, as you can imagine, because I needed some, let's say, traveling compass, no, in order to have maybe a simplistic but clear analysis at the beginning, also from my audience that was not always very familiar, with the federal, let's say, implications on the one hand, and the common law and the civil law doctrine. So what I wanted to let emerge, it was, this difference in values. But this would be what I would like to do also now in my view. So try to unpacking, to be this the word, what you said, because it's honestly, it's not so, let's say, Unitarian or the dimension of the state, not at all, for many reasons. And also in Europe, on the European dimension, there is the injection of the common law. So this would come for on the one hand, maybe it makes things a bit more complicated, but also much more convincing in terms, of final results. So many thanks for this. I'm going to explore this at the moment. Thank you for the suggestion. Please.
So this is very interesting. This is very interesting, and very complicated. And I have tried to get lost at the beginning. So I'm going to reveal my ignorance. I don't know anything about the law. And my difficulties have, I think, a couple sources. So one is, it seems to me, so if we go back to one of your early graphs, you have geometry of powers. And the only word of those three I'm comfortable with is of. So,
Are you sure about that?
no, actually, because prepositions are
Off is very hard.
prepositions are very complicated. But it's the one I have the best grasp on.
About.
Okay, so I'm going to start at the back with powers. So it seems to me you may be using powers, or I'm misunderstanding your use, in at least two different senses. So the sense that I first thought you were using it in was the sort of Hofeldian sense of the power to change the rights of individuals, right? To move a right from one person to another, to transfer Blackacre, which I own, to somebody else, right? So I have the power to do that in a Hofeldian sense. And I want to also say, so when powers are acting on rights, and what are rights? Rights, I understand to be allocating a particular decision to someone. It allows an individual, the holder of the right, to make choices, to choose whatever action they want, perhaps within some limited set. Okay, and so this is important to me because I'm interested in the behaviors that are going to be induced by the structures, the legal rules of the Constitution. So the Constitution is going to set up a structure in which people acting in that structure are going to allocate decision rights. They're going to allocate rights, and then holders of those rights are going to make choices. Right? So there's this very complicated structure. The other way in which you sometimes seem to be using power is in sort of a more physical sense, right? Where, so when we talk about the power of the internet, the power of the internet isn't, right, a power in the Hofeldian sense. It has something about its effect on actions that are available to individuals, right? It adds actions or it amplifies the action, right? So it changes the value of the choices that an individual might make. So that seems to be very different, right? So maybe I'm perplexed by Balkan's thinking of technology as an intermediary in the same way as the individuals and the governments.
Yeah,
So
I understand.
okay, so that's my problem with powers. Now, geometry, I've never been very good at geometry, so maybe this is
Me
just
neither.
reflecting
As you can
my. So I want to suggest as a domain for your metaphor. I should also point out, right? I have a very literal mind, so we started off in very different places. You start off with a metaphor, and I'm trying to be very literal. So that's. So I want to suggest a different area of mathematics as the domain for your metaphor. So in the area I have in mind is game theory rather than geometry, because game theory, what a game is, or more precisely, because I'm so literal, a game form is just the rules of the game. It tells you who has what powers, right? What decisions are open to each person in the room, each player in the game. So, and then the game is only fully specified when we identify who those players are. So, those of you in the business of studying constitutional law, it seems to me, are in the business of studying game forms, right? And deciding which game form is the good game form, right? And part of the difficulty of that is that any game form can be played by lots of different players. And how good the game comes out, how well you appreciate the game, is going to depend on who's playing it, right? So a particular constitution might work well for a population with one set of values, preferences, and not work well for a population with a different set. Okay. So I'd like clarification on whether I've disambiguated your use of powers or whether I've misunderstood your use of powers. And then just a suggestion about switching the area of mathematics for your metaphorical domain.
Thank you. So, as far as the second point is related, I regret that I didn't hear this before my submission to international constitutional law, because I'm sure that using this kind of theory and clearly be familiar with, and not, this would have mean much more enthusiastic acceptance. So thank you for this. It's very interesting what you're saying. It's exactly what I thought in terms of roles, in terms of decision makers, but I didn't know, honestly, that this could be encapsulated in the game theory. So thank you very much. I will try to understand more, and maybe to start with when you were being in NYU. Second point, it's also crucial because I didn't realize while speaking that might be such terminology confusions in terms of what do I mean when I speak about power. In my view, I try to, let's say, my idea was to try to demonstrate that from a constitutional law theory point of view, that we are playing in the play field of constitutional law, meaning that that kind of relationship between public powers in terms of public authority, okay, and private, is not, let's say, is not anymore, is not relevant anymore if such authority, in terms of, I don't know, impact, but then it's clearly important to understand what does it mean authority. Authority means the capacity to influence or to oblige somebody to do a certain behavior. In any case, I didn't go so much in let's say, in depth, unfortunately, and now you made me think about it, so I didn't go so much in depth. What I wanted to show it was just that authority versus liberty, no? In the classic world of constitutional law are still relevant even if such authority are private. Now, then, if you ask me, what does it mean and what does it entail to be a private authorities, I do not know exactly. I know that such authorities, maybe authorities could be a better word than power, I don't know, because power could be misleading. Such authorities have the possibility to influence in a very significant way the behaviors of especially new generations, let's be frank, new generation, in a certain crucial topic season of their life, like the voting season, because it's absolutely in a way proved that disinformation, for example, especially during the elections, the United States election, Trump versus Clinton, in that period, that was proved that that kind of information had an impact. Now, you can say you should not blame such platform, you should blame the professionals of this information that were based in Russia, that in a way created such business in order to have an influence. It's true. But I don't think that such platform should claim to be neutral, you know what I mean? To be totally outside the political arena, because they are taking benefits from being part of such agora, and they should also pay the price to be this. I'm not for criminalizing them, or for demonizing them, or for changing the immunities and responsibility. I just want to say that for sure the world is more complex in terms of who is taking decisions. Because the decisions are taken by many bodies, some are public, some are partly public, some are private, some are private but with strength in terms of sometimes revenues that are comparable to state. So in a nutshell, I don't know how to answer to your question. I think it's very important to be precise in the terminology. My idea was just to, in a way, in a more, let's say, simplistic way, to shift the playgrounds from a vertical to horizontal without changing the main ingredients of constitutionalism, that is limiting powers. But let me think about it, because it's very interesting suggestion.
So I realize that I wasn't thinking quite clearly when I asked my question. So your response suggests something else that might. So when we talk about the internet, your response suggests we're talking about two things at once that we've allied. We're talking about two things at once. So one thing we're talking about is the thing you started with, about the thing you don't know about, right? The technical thing, how this happens, right? Machine learning, right? All sorts of technological advances. But the other thing we're talking about are the entities, typically private entities, that are making decisions about the entity. Okay, so that's correct. And so when I said power as a physical sense, I was thinking about the internet in the first technological sense, the technology sense. But now you remind me that we should also think about these decision makers. But then, in this world of game theory, they're just other players. Right? So they don't look any different. Adding the introduction, this technological advance changes many things. It changes the ability of the types of decisions or the effects of decisions that individuals can make. It's also arguably changing the set of actors we need to look at, right, by these new private corporations who are doing things. So that's all.
So I see what you mean basically that it's not a question of power, but it's a question of adding a new actors in a setting of, yes, I see. It might be. It might absolutely be. Thank you. Please.
Thank you so much. I'll ask my question in English, but there is a means I can translate it. I have three points. I basically agree with the core thesis that is to say that the framework of constitutional law needs adjustment to respond to this new reality. But I just wanted to ask your opinion concerning 3 points of what you name a change in the relevant technological environment. A change in the relevant technological environment. That basically are new problems that admin law and also constitutionalism has to deal with. The first one is related to the idea of the rights and the limitations to rights. The word limitation in English cannot capture what we can express, for instance, in German with Eingriff, or in Italian, intervenzione in un diritto fondamentale. That can happen in internet. Like, for instance, I know Lady works in a very interesting field, which is how the new technologies can enhance the possibilities for people with mental disabilities.
Yes.
I am the rapporteur of the right of disabilities at the American Human Rights Commission, and I'm aware of the development of new technologies in which, for instance, the expression of the person is not needed anymore. There are devices that can literally read the mind of people with disabilities. So we are not anymore in the merely the free marketplace of ideas, because the digital world is not only anymore about ideas. It's about thoughts. It's about digital property. So, and constitutionalism, or the tools of constitutionalism, have not been developed to adjust to those new dimensions of fundamental rights yet. So that would be my first point. Then the second point, you mentioned one idea that Erin mentioned yesterday, and I totally agree with that, is that constitutionally borrowing or transplanting is dangerous. But there is a special issue concerning the digital world, and it's the following one. I think it is a very bad idea that, for instance, I take the social rights doctrine, adjudication doctrine from Colombia, and I transplanted it into the US, that would create a mess. But here there is another point, is that that jurisdictional challenge is even greater because of the following, because the same fact is pervasive to several jurisdictions. So when I talk about social rights, I can just simply disregard the idea that we have a model in Colombia, another one in the US, and people can very easily disregard the different models and can say, I use my own and that's it. But concerning internet, let's think about, for instance, the person who created Canva.